It is against of marriage law, stating that I'm not going to marry, or I'm not going to marry now, or I'm not going to marry at all. If I say it is against to the law, whatever we have in the present in the law act. When you change your residence, or when you're going to change the employment or the profession of the business what you're doing, or the nature of business what you're doing, so then the contract made between the parties is void. Agreement by a minor, if you're going to make any contract or any agreement with a minor who is less than 18 years, then it is void. Warm welcome to 4th Sem BCom student. The subject we're discussing business, regulatory and framework. I'm Professor Rajesh L.R. from Commerce and Management Department from Vidhyaashram First Grade College, Temple of Excellence. In our previous session, we discussed about the Indian Contract Act, free consent, coercion, undue influence, fraud, misrepresentation, and void and illegal contracts. In today's session, we're going to discuss about agreements void, varying agreements, performance of contract, conditions for performance of this is a concept what we're going to discuss in the present session. The first one, agreements void as being opposed to public policy, means when it is against to the law, so then the agreements are cancelled. So here, agreement in restrict of parental rights, an agreement by which a party deprives himself of the custody of his child is void. They're saying that when it is the concept of illegal, it is there. So then such type of agreement is totally void here. It cannot be a valid concept here. Agreement in relation of marriage, an agreement not to marry at all or not to marry any particular person or class of person is void, as it is restraint of marriage. They're saying that it is against of marriage law, stating that I'm not going to marry, or I'm not going to marry now, or I'm not going to marry at all. If I say it is against to the law, whatever we have in the present in the law act. Marriage brokerage or brokerage agreements. The brokerage agreements, an agreement to procure marriage for reward is void, where the Purohit was promised rupees 200 in consideration of procuring a wife for the defendant. The promise was held void as opposed to public policy, and the Purohit could not recover the promised sum. They're saying that whatever the Purohit has paid here, that is against to the law here. It cannot be stand as a valid here. Agreement in restraint of personal freedom or void, when a man agreed with his money lender not to change his residence or his employment, or to part with any of these property, or to incur any obligation on credit without the consent of the money lender, it was held that agreement was void. What they're saying that where a man agreed with his money lender not to change his residence, he said that I'm not going to change the residence here, or I'm not going to shift to any other organization on employment basis here. When you said that when you change your residence, or when you're going to change the employment or the profession of the business what you're doing, or the nature of business what you're doing, so then the contract made between the parties is void. Void agreements, agreement made by incompetent person, like for example lunatic, insolvent. These are the people, if you're going to make any contract between these two parties, then it is called void agreements. What is lunatic? When a person is unsound mind, or when a person is totally in a drunken stage, and when you're making a contract between a person who has drunk fully, and if you made the agreement between the party at that point of stage, that cannot be accepted here. Insolvent is nothing but the court has given an order stating that this person is not capable to enter to any contract because his debts are more and his income is zero, and is an insolvent person. He cannot make any payment, and if the contract is made, either the government or the court will not support for such type of contracts made between the incompetent parties, and it is always a void agreement or contract. Agreement made under a bilateral mistake of fact, agreement of which the consideration or object is unlawful when the consideration is not according to the act or to the required party, agreement of which the consideration is object is unlawful in part, a part of the consideration is not according to the law, agreement made without consideration, if there is no consideration then no contract, agreement to do impossible acts, like you made an agreement stating that one, I'm going to jump from the 100th floor and I'm going to survive without any damages to my body. That cannot, and it is not possible. So that is the reason they're saying that if you are making any agreement which is not possible, such type of agreement is void. Agreement in restraint of marriage, as I said, I'm not going to marry at all. If you're going to say it is against the agreement in restraint of trade, you're going to say I'll not make any type of trade, you're doing the business activities. When you're in the business and if you give a statement that one, I'm not going to buy any product, then what you're going to do the business here. So such type of things are void. Agreement in restraint of legal proceedings, agreements void for uncertainty, wagering agreement. These are the agreements which are declared to be void, means cancelled. Void agreement. Next one, agreement by a minor. If you're going to make any contract or any agreement with a minor who is less than 18 years, then it is void. Already I said that one, unsound mind. When there is no consideration or the object is not according to the required part, then it is cancelled here. Agreement in restraint of marriage, agreement is restraint of marriage is void, exceptions, minors, and reasonable period is valid. Agreement in restraint to trade is void. Already I've given all the concepts here. You just go through that one. Exceptions, a contract by which the parties agree that any dispute between them shall be referred to arbitration and will not be taken to the court as a valid contract. If there is any certain exceptions are there for certain agreement, that cannot be taken to the court, stating that one it is a valid contract, even though it has certain exceptions for the agreement made between the two parties. Wagering agreement, the literal meaning of the word wager is a bet. So it is called betting, or nothing but ordinary betting agreements. A and B enter to an agreement that if England's cricket team wins the test match, A will pay B rupees 100, and if it loses, B will pay rupees 100 to A. This is a wagering agreement and nothing can be recovered by winning party under the agreement. C. If A and B made an agreement between them, A is going to pay rupees 100 and B is going to pay 100 when B is going to pay 100 to A when the England loses the match, right? Now, A will pay rupees 100 if England wins the match. So now there's a concept what we have here. It is a betting concept. What between the A and B is happened here, that cannot be called as a valid contract because it is a betting contract. Betting contract is always a wagering agreement and it cannot stand in the court of law. Performance contract. Every contract has certain obligations, nothing but duties, which are to be performed by the parties to the contract. The offerer and the offeree, both the person has to perform all the terms and conditions of the offer. When both the parties to the contract have performed their obligation, the contract is said to be discharged by performance. When both the parties, as per the terms of offer, the offerer and offeree has completed the every concept of the offer terms, then it is called the offer or the contract is discharged by performance. Promisor himself, legal representative. However, if the contract involves personal skills, if the promisor dies, the contract becomes void. See, if anything happens to the offerer or offeree, automatically the contract is called void. It cannot stand for a long run. Agent of promisor, third person, if the promisor permits. Means they're saying that if the contract permits a third party to enter into the contract, then it is going to stand, or else it cannot be stand in the market. Effect of refusal to accept offer of performance. When the promisor make offer to the promisee for the performance of the contract and promisee does not accept it, then the promisor is not responsible for non-performance. When the two parties, one of the party as not performing its duty, then the contract is always going to be void. It is not a valid contract because one of the party is not performing its duties. When is not performing the duties according to the agreement made between both the parties, that cannot stand here for a long run. It must be unconditional. When you're going to make any rights or rules and regulation, it should be unconditional. Performance must be at a proper time and place. The agreement what you're going to make, it should be stating that one either 1 month, 2 months, or 3 months, or 1 year, or 2 years. It is not like that 500 years, 1000 years, 2000 years. If you're making with that concept, the time period what you made is not proper and it is against the law here, so that cannot stand for the called as a valid. It is a void. Performance must be within reasonable time. As I said, okay, I'm accepting all the terms and condition. You just supply the goods to me. I'm going to pay the amount for you within just 100 years. Can I say like that? No. When the party has given the goods to you, that has to be paid, the amount for that has to be paid within a reasonable time, not in an unreasonable time or whenever it is possible to you. That it is not possible here. Performance must give reasonable opportunity for inspection. Means that to give a certain time period to accept that and whether the product is as per the sample or the terms and conditions of the offer made by the offerer, then it is going to stand. And if the sample is shown is different and the product supplied is different, then definitely the contract is void. Effect of refusal of party to perform promise wholly. The total contract can be cancelled. See, like Kanika Kapoor, a singer, enters into a contract with the Neha Dubya, the manager of a theatre, to sing at his theatre 2 nights in every week during the next 2 months. And Neha promises to pay her 100 rupees for each night's performance. On the 6th night, Kanika willfully absents herself from the theatre. Neha is at liberty to put an end to the contract and it depends on her choice. Now, when I'm not performing the duty here, the offerer has all the rights to cancel the contract and the offeree cannot come and say that why you cancelled without my consent. When you're not performed your duty, the offerer has all the rights to cancel the contract. Effect of accepting performance from the third person. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promiser. When A, B, and C are there, A and B have entered into contract, but C is accepting on behalf of B. On behalf of B, C is accepting the contract here. Liability of joint promiser is joint and several. If any joint promisor dies, his legal representative must jointly with the surviving promisors fulfill the promise. When anything happens to the B, C should be responsible to complete the contract. This is the concept what we have here, devolution of joint liabilities. C, the concept what we have here, each promisor may compel contribution. When they're saying that one, whatever the agreement we are going to make here, that should be with the amount of consideration only. If there is no consideration, it cannot be called as a contract at all. Everyone will contribute equally or as per the terms and conditions agreed between the joint promisor. Means both the persons as per the terms and conditions of the offer made by the offerer and the offeree was accepted all the according to the terms and conditions offered and accepted, the contract has to be executed properly. Performance of contract, devolution of joint rights. When a person has made a promise to two or more persons jointly, then the right to claim performance rests with all the joint promisee, and if any of the joint promisee dies, then the legal representative of that joint promisee along with the surviving joint promisee shall claim the performance. When they're saying that one, A, B, C, D, these two people have offered to CD, and CD has accepted the terms and condition of the offer. If any one of the A and B, if B dies here, A has to perform according to the terms and condition made by them, and he has to perform his duty. And if D dies here, C has all the rights, and C is liable for the contract whatever they've made between A and B, and they have to execute the work as per the terms and conditions agreed or made. Time and place for performance of contract, already I said that one. For all types of contract, the time should be given at limited time, or what you can say, when actually the contract is going to be executed on the time period. It should not be beyond the limits. Like, for example, as at 100 years, 200 years, 500 years, 1000 years, 2000 years. The contract cannot be made for certain number of years only. Time and place for performance of promise, where the time is specified. They're saying that when you specify the time and no application to be made, so then, like for example, Mukesh promised to deliver goods at Rahul's warehouse on 1st January. You have accepted to deliver the goods on 1st January. On that day, Mukesh brings the goods to Rahul's warehouse, but after the unusual hour for closing it and they are not received, Mukesh has not performed his promise. Means Mukesh promised to deliver goods at Rahul warehouse. They said that one, I'm going to deliver the goods to you on 1st January. On that day, Mukesh brings the goods to Rahul's warehouse. But after the unusual hour for closing it and they are not received, Mukesh has not performed his promise. Means Mukesh has not delivered the goods on exact time when it should be delivered. If he wants to deliver the goods after the closing time of the business hours, it cannot be accepted here. Place for performance, it should be in such a thing that one, where the goods will be delivered and how the goods will be delivered and where we are going to perform the contract. Everything should be mentioned in the terms and conditions of the offer made by the offerer to the offeree, and offeree has to accept all the things, or he may give the counter offer stating that one, this is the place where it is required for me and at this particular time, and this is the office hours or working hours, it should be delivered within the office hours only. If the delivery comes after the office hours, we are not going to accept that one, because we will not open only for the part of receiving the goods after the official time is over of our business terms and condition, whatever we have here. In our next session, we are going to discuss about performance of reciprocal, time is essence, agreement to do impossible acts, appropriation of payment, quasi-contracts, and types of quasi-contract. This is a concept which we are going to discuss in our upcoming session. Thank you to all 4th Sem BCom students. In today's session, we discussed about agreement, wagering agreement, and even the essential things, whatever it is there for the void agreements. Thank you to all 4th Sem BCom students. Namaste.